When we're talking about removal proceedings, we're talking about the process by which the government, immigration, moves to remove or deport someone from the United States. There are different ways to get into removal proceedings depending on the posture of your case. So if you're detained at the border, or you lose an asylum case and are referred to court, etc. But the basics of the process is this. First, the government will issue a notice to appear. At the top, it will say notice to appear. People often think that this is a warrant for their arrest, but it's not. The notice to appear is a notice telling you to appear before an immigration judge. At the top, it'll say notice to appear. It'll have allegations 1 through whatever. It's usually 1 through 4, 1 through 5. The first allegation is always you are not a native and citizen of the United States. Number 2 is you are a native and citizen of X country. And the rest of the reasons why immigration thinks that you are removable. Then after that, you're going to see a charge of removal, the basis in the law of why you are removable. So that will always start with INA 212 or INA 237. And then at the very, very bottom, you'll see a time, date, and place for your first hearing called the master hearing. You have to appear at that hearing or else you will be deported. You will be ordered deported even if you're not there. The next step is to show up at the master hearing. We call it usually the master or the master calendar hearing. And that's similar to what in criminal court we call the arraignment. So you will appear before a judge with other people and you will plead to the charges and the allegations. So you'll tell the judge whether or not you agree with them. This is really a strategic decision for which you really should have an attorney, because often we will deny allegations and deny charges of removal because it puts the burden on the government to prove the allegations and the charges. Again, this is the strategic legal decision. Once the judge makes a decision that you are removable, they will ask you if you'd like to apply for any form of relief. And then most people will say, yes, I want to file for asylum, or I want to file for cancellation of removal, or I'm going to file for adjustment of status based on my marriage, whatever it may be. After that, the judge will set an individual hearing date. The individual hearing is what we also call the merits hearing. You're presenting the merits of your case to the judge. At that time, you will be able to present witnesses, expert testimony, evidence, your testimony, and whatever else you need to do to prove up your case. Your attorney will ask you direct examination questions. The government will have an opportunity to ask you cross-examination questions, and oftentimes the judges themselves will ask you questions. At the end of that hearing, the judge will either make a decision or tell you they're going to mail out a decision listing out the reasons for their approval or their denial. That's the basics of removal proceedings. After that, you move on to the appeals process, first at the Board of Immigration Appeals, and then if the Court of Appeals has jurisdiction, you would next file a petition for review in the U.S. Court of Appeals for whatever circuit you're in.